And so
under your theory, a partner or an individual debtor whose partner is guilty of fraud, the individual debtor may well benefit from it, since it's the money may well go to something, assets for the partnership. She knew about the fraud, didn't do anything about it, and yet you would say her debt can be discharged. She isn't liable at all for the results of the fraud.
I would say it depends on the circumstances of whether there is a sufficient level of knowledge and acquiescence.
She knew about it. She knew about it.
Right, but the question would be the circumstances of, in addition to knowledge, was there some sort of acquiescence? Was there a duty?
She knew about it and didn't do anything.
Right, and so I think that still begs factual questions with respect to whether there is a duty of that person to disclose some representations to the person who is defrauded, or whether there is a reckless indifference and ability to control the fraud, all of which would come under direct liability. And so the case is it's not the case that you can just sort of sit idly by and say, I know about the fraud, I have the ability to control the fraud.
It's not the case what? It's not the case
It's not the case that person would get off the hook, because that is direct liability. The thing that you don't get is vicarious liability. So in the case, it is not sufficient just to have knowledge, but if there is...
I'm sorry, direct liability what? Under applicable state law?
No, the direct liability would be the line I think the court drew in Gebser, and is the traditional concept in the restatement second of torts, which is when you say the debtor or another actor in a statute, who do you mean for purposes of direct liability if the statute does not include vicarious liability? And Gebser is probably the best case answering that question by saying the minimum for direct liability there for a school district is that the school district needs to be on notice of potential harassment, needs to be willfully blind even to that, and have the ability to control that from happening. And so that, I think, is the probably minimal level for what you would have for direct liability for fraud. So it is just not the case that people are getting off scot-free for essentially acquiescing or encouraging fraud. And just to take a step back for a second, in terms of how this rule also cashes out, most people who are sophisticated enough to know that they're actually forming a partnership also know that they should form an LLC in order to avoid liability. So the people on whom this rule actually falls today are people who don't know they're forming partnerships under state law, where the bar is pretty low.